Welcome to the Probate Nation. As your loved one ages, they are confronted by various medical challenges. Sometimes those challenges result in a hospital admission to treat the medical problem. And often they are discharged from the hospital to a rehab facility for a period of time. Or the loved one can no longer live at home due to the nature of the medical challenges and takes up permanent residence at a nursing home near you. Our show this evening begins a discussion about the treatment provided your loved one at that rehab facility or nursing home. What is the standard of care that your loved one should expect? What are some signs that that standard of care is not being met? What can you do to address concerns you may have? And can an attorney be helpful in evaluating whether your loved one is the victim of nursing home abuse? All good questions, and we are pleased to have as our guests tonight two attorneys who deal with nursing home abuse in the regular course of their law practice every day. They will help us address these questions and others as we begin this important discussion about the care your loved one is receiving or not receiving, as the case may be. Our first guest is a partner in the Metro DC law firm of Coons, McKinney, Johnson, Napolis, and Lightfoot, where he handles cases involving serious injuries arising from auto accidents, construction accidents, medical malpractice, and nursing home abuse. Prior to joining his law firm in 1980, he clerked for a DC Superior Court judge and then served as an assistant U.S. attorney in D.C. from 1977 to 1980. He has been a member of the Fairfax Bar Association since 1985 and served as its president from 2001 to 2002. Our second guest is a partner at Ashcraft & Jarrell and the chair of their Nursing Home Abuse Litigation Department. He is the chair of the Virginia Trial Lawyers Association Long-Term Care Litigation Section and a member of the Maryland and National American Association for Justice Nursing Home Litigation Groups. He lectures nationally on nursing home abuse and neglect to both attorneys as well as family and caregivers. Please welcome Peter DePaulis and Joe Musso. Gentlemen, thanks very much for coming.
Thanks for having me.
Yep. Good to see you folks. Nice to talk to you in person. Well, Peter, let's start with you and talk about the standard of care.
Sure.
What is the standard of care required of nursing homes in caring for their residents?
The standard of care is basically what a reasonable person should expect to receive by way of care. The standards are set in many cases by Medicare regulations, and this is a medical negligence inquiry, so you have to have experts in that field of medicine to come in to educate you as to the value of your claim, whether or not you can prove it, and to help the jury understand what is a breach of the standard of care, which is the definition of negligence.
So the standard of care does not vary then by jurisdiction?
It doesn't vary that much by jurisdiction, although a prudent practitioner will always have a Virginia practitioner opine on a Virginia case. That just avoids some problems with the judge and jury later on.
Okay. Well, Joe, what are some of the common reasons that the standard of care is breached?
I think in the nursing home context in particular, these deviations from the standard of care are generally the result of business decisions. It's actually not the typical nurse that goes into the practice of nursing to take care of elderly folks or frail folks with the goal of abusing and neglecting them. It's actually much higher. Bean counters, accountants, people who are making business decisions, such as, do I want to add another nurse? Do I want to add another aide to that shift at night when family's not going to be there, the state's not going to be there to investigate? And actually what ends up happening is well-meaning caregivers end up in situations where they simply can't take care of all of the residents. So, obviously it is, as Peter just pointed out, it's a medical malpractice case, at least that's the way the law looks at these cases, but in my experience, these are actually business malpractice cases. Are these facilities that are understandably trying to make a profit, operating their business in a way that empowers their staffs to provide the very best care that they can. And that's what those federal regulations require, that they maintain the highest practicable level of function that they can for our residents.
But as we've talked about during the course of the pre-interview, really have not been successful in suing people for business malpractice and basically, or their business decisions, really.
Yeah, I mean, look, the jurisdictions have called them medical malpractice, and ultimately, at the end of the analysis, you do end up with a situation where a medical mistake occurs. But again, 20 years doing this, my experience says that those are the results of business decisions. And if you look close enough, what you're going to see behind that, again, is usually not an incompetent nurse or an uncaring nurse. What you're going to find is an overworked nurse.
That's right.
Oh boy. Now, what can folks who are, going to put mom or dad in a local nursing home or getting them discharged from the hospital to go to a rehab facility, what can they do in order to make good choices about placing mom or dad? Peter?
Well, they can certainly do their research online because there's a treasure trove of information that's available to anybody who wants to look to see how that facility is rated, what the complaints have been, what the customer satisfaction has been. So there's a great deal that people can do if they have the time prior to admission to do some research. And most people are in a pressure-filled situation where their mom or dad or an elderly relative suddenly has to go into a nursing home, and you may not have weeks or even days to do the research. So hopefully you can go ahead and jump on it pretty fast and find out as much as you can find out, and pay attention to the ratings that these various facilities have, because they are based upon actual experience.
Okay. Well, let's turn the next page here and look for the signs of abuse, because they do manifest themselves. And Joe, tell me, in caring for a patient, what is the common and acceptable approach to do so?
It's an acronym that nursing home abuse lawyers use all the time. It's API. Assessment, plan, implementation, and evaluation. Every resident that comes into a nursing facility should be assessed. And that just means basically, can I identify what risks are facing that individual resident? It's not cookie cutter approach. These people all have different problems, different issues. You can't treat every single resident the exact same way. You have to identify what their risks are, plan to address those risks, to mitigate those risks, and to minimize their occurrence. And then if you have a really good, objectively verifiable, measurable plan to address those risks, then all you got to do is, like Nike says, just do it. Then you got to actually implement the plan. I mean, having a great plan, I can tell you from trying to diet, having a great plan is useless if you don't actually do it. So they have to do it. And then finally, if they've assessed correctly, they have a good plan, they've implemented the plan, but negative outcomes continue to happen, whether it's pressure ulcers, falls, whatever the problem is. You can't just say, well, we assessed and we planned. You have to then evaluate, and that's the E in the API model. You have to evaluate and say, did we miss something? If someone keeps falling down and you have non-skid socks, but they don't actually walk, you might have a plan to prevent someone from falling, but not somebody who doesn't walk.
That's a good point. Well, Peter, what are some of the red flags to watch for at the nursing home that would indicate that someone the standard of care is being breached in their care?
Well, certainly, if you have a loved one in a nursing home facility and the loved one seems very, very unhappy with being in the nursing home. No one's happy being in a nursing home to begin with.
No, of course not.
But if their mood is radically different from what you normally expect, that could be the sign of bad care. You have to be very, very aware of how crowded does this facility appear to be? How clean does it appear to be? If your instincts tell you that something is wrong, if you see something, say something. Okay? Call the attention of a nurse that something is not clean, something is not picked up, somebody is worried about some care. There are signs and symptoms that are very obvious, particularly with the benefit of hindsight after something bad happens. And every room that has a fall risk patient should have signs posted that this person is a fall risk, so that next provider will be alert to the fact that this patient needs some extra help going to the bathroom, walking around the room, getting up and down the chair. So there's a great deal that people can be aware of by just looking carefully, asking questions. And if something seems wrong, then say something. Don't be shy.
So, Joe, talk a little bit about what are some of the red flags to watch for the condition of the patient itself in the nursing home that may begin to flag that there's an issue.
I mean, just like, echoing some of the things that Peter just said. I mean, if you had a kid who came home from daycare and who was normally boisterous and fun-loving and excitable, and they're withdrawn and sullen, we wouldn't even think about saying, well, maybe something's going on at daycare. But for some reason, in the nursing home context, we're okay with all of a sudden mom seems withdrawn, she stops eating. And you have to understand that there could be nursing staff telling you, well, this is the aging process, this is normal, because they, quite frankly, don't want someone poking around in their jobs. The reality is, this is why it's so important that we have empowered caregivers that are paying attention, visiting often, and staying in touch with their resident, because you're the best person to assess whether or not there's a change in your loved one. If you come in and your loved one is laying in a dirty diaper because they're incontinent, and you ring the bell and nobody comes, that's a real problem. I mean, I tell everybody that I talk to who has a loved one in a nursing home, the first thing you should do when you walk in is ring the bell. How long does it take for someone to come? If the answer is 5 minutes, wonderful. If the answer is 50 minutes, you have a problem on your hands. It's really, a lot of it is common sense. And the big problem is, unfortunately, and for whatever reason with nursing home families and nursing home facilities, I see too often that there's this delegation or turning over mom or dad to the nursing home's care. It's a collaborative effort. You have to be involved with the resident. You're the one who's the expert on the resident. They may be the expert on the nursing and the medicine, but you're the expert on that resident. If things are changing, you're the one who has to speak up.
Now, I mean, to continue with that conversation, Joe, so a lot of the abuse really kind of breaks down based on our discussion when we were planning for this program, breaks down into certain types of things you see on a regular basis, you know, so 90% of it is in a certain category. You can talk a little bit about those breakdowns, Joe?
Well, in the work that Peter and I do with regard to bringing lawsuits, certainly we see a disproportionate amount of pressure ulcers, which are open wounds that are caused by being left in one position on what we call a bony prominence, so your elbows, your back of your head, your tailbone or your sacrum, your heels, where unrelieved pressure literally wears out the skin and stops blood from getting down there, and you have cell death and wounds can form. That's 90% of what I see are pressure ulcer cases. There's also falls with fractures. There's also, of course, elopements and sexual assaults. There's a lot of different types of abuse, but I would say the vast majority of them fall into the pressure ulcer and falls with fracture category.
Okay. Well, Peter, let's talk about investigation phases.
Sure.
Because we go through a series of steps and we don't always immediately run off and file a lawsuit because someone has has bed sores. Okay, so the initial consultation. What information is gathered and what's discussed at this particular stage?
Well, at the initial meeting with the client, we have to talk about who's going to get the medical records and how is that going to be done. These cases, for the most part, rise and fall on what's in the medical records. So getting access to a complete copy of the medical records, not partial copies, but a complete copy of the chart, is of paramount importance. Sometimes we do it two ways. We have the client get it, and then later on down the road, we'll also request it, and we compare the two copies to make sure that everything the client has gotten is the same as what we've gotten.
How interesting.
So records review is the key, because that should be the roadmap of the care that was or was not provided. So records review is very, very important. Later on, your expert, he or she is going to have to look at those records and render opinions based upon what's in those records. So that's the key.
So the first part, the first initial consultation, is that generally something that is a for free consultation at that
Yes,
point? You're just basically...
indeed. The attorneys who do what Joe and I do, we don't charge for our time. We're not a billable hour type practice. It's strictly contingency. So we have to be efficient with our time. We encourage the clients to be efficient with their time, but getting those records is really the first step in the process.
Okay, so Joe, let's take a look at the next level. Before the lawyers actually retain, is there any sort of post-consultation work that's done to guide the client as far as things they need to do?
Before an attorney is retained?
Yes. You've gone through the initial consultation, you've given them some marching orders.
Oh, I see.
And now is there any sort of follow-up that normally occurs before they actually retain?
In my experience, I think one of the really big keys is data gathering, information gathering. It's like building a house. You really have to have a really strong foundation before you go putting the roof on. So it may seem silly at the beginning when you're first meeting with a lawyer like us and we start asking you about social security numbers and prior addresses you lived at and your entire medical history, which for a 90-year-old can be pretty extensive. It's not because we're just trying to gather a bunch of information. It's because at some point in the case, that prior medical history is going to become important, particularly to the defense. And so we have to make sure we're cutting that off at the pass. So there's going to be an incredible amount of information that we're going to ask you for. And I can't tell you, and I'm sure, Peter, you feel the same thing, how many times clients go, well, what does this have to do with the time mom was in this facility? And you just go, trust us. It's going to become important where mom was 10 years ago.
Right.
So once the lawyer, again, we're in the process now where we have someone that's come to the office, they've identified some problems, you begin to talk with them about it, you're gathering information. So now they retain you. to get to actually initiate, maybe a claim of some kind. What investigation work is now done at this stage, Peter?
Well, the critical thing is to make sure you have every record that's relevant to your issue, because you have to hire an expert to help you review those records. And before you're allowed to proceed with litigation, you have to have certification that you have an expert in the same field of medicine who has reviewed the chart in the case and renders the case to have merit. Okay, you can't just file a lawsuit and hope and pray someone's going to pay you some money. It doesn't work that way. You have to do all this legwork way before you're even near a courthouse. You have to be sure you can prove the case to a jury if it goes that far.
That's important to know. Now, once the litigation is filed, Joe, how do things unfold from there as far as the ongoing investigation phases?
Now you're going to enter formal discovery. I mean, the defendant is going to start attacking your complaint and start attacking your initial filing, which is kind of par for the course. And this is why the work that Peter just described is so important, that you have a certificate of qualified expert in Maryland, certificate of merit in Virginia, that you've filed your 162802 notice in DC within the proper time. You have a lot of prerequisites to filing one of these cases, and the first thing the defense lawyer is going to do is challenge you on all of that to make sure that you did it right. But presuming you do, you get to kind of go on the attack, and you get to start asking for discovery, whether it's interrogatories, which are written questions, requests for admissions, requests for production of documents. There's a whole lot of documents. Nursing homes are as regulated as nuclear power plants. There's a lot of documents and forms that a nursing home has to submit to the state and federal governments, as well as HIPAA compliance issues. There's a lot of records they have to keep, and quite frankly, we want to see them. When we take one of these cases. So the beginning phase, once you file the lawsuit, is the fight to get that material.
Okay. So let's talk about, Peter, the insurance coverage for nursing homes. So do they have coverages to protect them and pay these types of claims?
For the most part, yes. And in Virginia, a nursing home is, under most circumstances, required to have at least $1 million in liability coverage. That's different from an assisted living facility, which is only required to have $500,000 in liability coverage in most cases. Some have more. There shouldn't be any example of people having less, because there's a statute that requires a certain amount of coverage in both Virginia and DC. The real issue is that people need to understand that within that $1 million of coverage, every conceivable damage that you can claim, medical bills, things of that nature, is covered by that cap. So we're not talking about an endless supply of money that's available. Even in the most horrific case, sometimes you're limited by the insurance coverage that happens to be available.
Okay. Jill, let's talk about pre-litigation resolutions. We had a chat about this, and I know that that's not something that generally, but we like to get these cases settled and not spend lots and lots of time if we can avoid it when we know kind of where this case is going to go. Is it possible to settle these cases without filing litigation?
I'll say it is possible. It does happen
sometimes,
but I would say that it is certainly the exception, not the rule. Peter and I were talking in the green room about how, as you kind of go through this career, and I've been a nursing home abuse lawyer for 2 decades now, you eventually start seeing the same people over and over again. And some of the fighting you've done on case A spills over to case B, where you talk to that same lawyer and you say, this case is a whole lot like that other case we had. Maybe we can short circuit 2 years of war and maybe mediate the case or have a conversation about that's going to be easier for everybody. But defense lawyers bill by the hour, so they don't really have much of an incentive for a quick resolution.
And people should understand that if you initiate an inquiry and you think it has merit, you should prepare that the case is going to go to trial.
Agreed.
With that mindset may come a good resolution, but if the other side smells that you're afraid or unprepared to go to court, they will pay you nothing, ever. So you have to put your game face on, get ready to get up at bat and hit a home run, because otherwise the other side senses weakness and they won't pay you a dime.
Okay. Real quickly, Peter, because we're going to start to run out of time, are common challenges that you are confronted with in bringing these types of cases?
Sure.
A couple of points you might want to make.
There's 2 that I focus on. Is The issue of liens, if a person is a Medicare recipient, under many circumstances, we have to repay the government for whatever care is provided as a result of the malpractice. The other thing is that you have to manage people's expectations. People who have a loved one who's been abused or suffered some injury in a nursing home, they're upset, they're angry, they want a sense of justice and fairness, and you have to help mold their expectations to be realistic, because the cases are expensive to litigate, and sometimes they're not successful, not because you haven't worked hard, just because the facts may not support your claim. So managing expectations is key.
Okay. Joe, let's talk about the role of legal counsel, because legal counsel is threaded throughout this discussion we've been having here. So, you know, patients come out of a hospital, need to go to a rehab facility or nursing home. Can a legal counsel be helpful at this stage?
You know, I advise someone every week in a situation like that, but that's about all I'm doing. I'm advising. The reality is there's not a ton you can do before an injury occurs when you're one of a lawyer like us. You can't bring a lawsuit that's going to cost potentially $50,000, $60,000 in costs because someone lost dentures or lost your sweatshirt, or things that you have a right to be concerned about, but don't rise to the level of a medical malpractice lawsuit in the jurisdiction. There are agencies out there, and I routinely refer people who call me and ask questions to the Office of Healthcare Quality in Maryland, the Department of Health in DC, and the Department of Health in Virginia. Those agencies are created to respond to complaints like that. And if you call them, but under the operation of law, they have to investigate those things. So certainly we do that. You can hire lawyers to go to care plan conferences, but that's probably better for a geriatric care manager to do.
Okay. And I know that we've talked a little bit that generally lawyers who are retained to pursue these types of claims generally charge on a contingency fee basis, but there are costs. Okay, so I know there's some distinction in the jurisdictions as far as whether or not those costs have to be paid for or cannot be paid for. Joe, what's the distinction there?
Well, costs are not contingent. There is in DC, technically you can make them contingent, but generally the fees are contingent, meaning the work that we do, that our staff does, that is contingent, meaning that if we don't win, you don't have to pay anything for our work. Costs are different. Costs are filing fees, expert fees, court reporters, all of the out-of-pocket stuff that we pay for to advance the lawsuit. That is traditionally not contingent, and that remains the responsibility of the client, which is a reason why we have to be really careful. And a lot of times the client will come to you and say, well, why do you think we need to resolve this, or why do you think you can't pursue this? And it's not because we don't want to pursue your case. It's because at the end of the day, if the facts don't merit it, we're going to end up costing you a lot of money instead of making you money. That's actually possible, and we want to obviously avoid that.
Of course.
And doing your cost-benefit analysis, as Joe just said, you have to be realistic. The case is going to cost X number of dollars to prosecute. So by the time they pay the attorney's fee and the litigation costs, you have to be sure there's enough left over for the client to make it worth the client's worthwhile. Otherwise, you've disappointed them yet again.
Okay. Well, I think that really sort of leads us into our last thing. We have just a very little bit of time here, but maybe briefly, each of you can give me some practical advice and some closing suggestions for folks.
Be involved, pay attention, visit, ask questions. Again, it's amazing how differently we react when a child comes home from daycare with a bruise versus when we come to a nursing home and see our mom with one. There is no difference. If they're in the custodial care of somebody who's tasked and paid to take care of them, we have every right to ask what happened. We have every right to ask who was involved. Nursing homes walk around a lot of times, staff walks around with no name tag. If your child had a giant open wound from daycare, would you be okay with not knowing their name? We have to be involved, and we have to know what's going on. If a doctor came to you for your young child and said, does she have any allergies? The answer, isn't you should check the medical records. For your kid, you'd be like, you'd know all the allergies, you'd know the medicines, you'd know the conditions. It's no different when you're dealing with an elderly person that you're tasked with caring for.
Okay. Peter? It's simply, if you see something, say something. Make sure everybody knows who you are, that you're involved, you're polite, you're professional, but you're also entitled to get answers. Something seems wrong to you, you have a right to raise a question, and don't stop until you get a reasonable answer. Not a perfect one, but a reasonable answer.
Guys, this is a lot of information. Great stuff. And of course, I know we've only touched the tip of the iceberg because there's so many other rabbit holes we can go down here. But thank you so much for taking the time and talking with us. And great public service to the people of Northern Virginia.
Thank you.
You're very welcome. With the aging of our population, more and more seniors are spending time in rehab facilities or taking up permanent residence in a nursing home. How your loved one is cared for at these facilities is important to your loved one and their family who care about them. What we learn from this show is the following. The standard of care your loved one should expect really is related to their needs. The signs you should watch for that indicate the standard of care is not being met include, in many cases, open sores, bruises, or worse, broken bones. Many nursing homes are understaffed. The role of an attorney in dealing with nursing home abuse and the point at which it is wise to get an attorney involved. How the level of investigation rises as the evaluation of nursing home abuse intensifies. Not all breaches of care merit pursuing a claim. Common challenges that these types of claims present, and much more. In an upcoming show, we will continue this discussion as the investigation accumulates details and opinions that result in the filing of a lawsuit in a local Metro DC court. How that litigation unfolds will provide you with valuable insight should a loved one suffer abuse while residing in a local nursing home or being treated at a rehab facility. This brings us to the conclusion of our show this evening. Hope you found it informative. And remember that replays of the show can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.